welcome back to the podcast relating to AI, where we explore how bots are changing the way we connect. Today, we're talking about one of the most controversial topics when it comes to artificial intelligence: copyright. The basic question is, who owns creativity in the age of AI? One side of this debate are the AI companies. They say that they're doing all this training, these chatbots, they get all this copyrighted material for training, but that's fair use. And we're going to understand what that means today. On the other side are the creators themselves. They're saying, no, you are using what we create, that's theft, because we're not being paid for the content. And to untangle this knot, this legal and ethical knot, we're going to have a lawyer with us today, someone who specializes in regulation and AI. We're here today being joined by Kevin Frazier. He is specialized, like I said, in AI and regulation, but also a professor at the University of Texas. Thank you so much, Kevin, for being here with us. What a knot you have to untangle today.
What a knot. I would say at least a double knot, if not a triple knot. Thank you so much for having me. It's great to be here.
Yes. The first question I have for you is, so these companies, they say, no, we're using all this copyrighted material. We have songs, we have books. I mean, you name it. Like you, a researcher, we have all these articles. We use it all, but that's fair use. That's transformative because people are going to use it to transform. They're not going to repeat what's out there. So the first question for you, and I want my listeners and my viewers on YouTube to understand, is what do they mean by the term fair use? What does that even mean?
So, Paula, you set it up excellently in your intro, noting that this is a legal question and that it is an ethical question. So I want to just take one step back because I wouldn't be a good lawyer if I didn't fight the question just a little bit.
Of course.
Because it's important when we're talking about copyright to actually go to the source of copyright law and the source of intellectual property law, which is the IP clause in the Constitution. So for those listeners and watchers who don't have their handy dandy pocketbook Constitution ready to go, the IP clause says that Congress can promote the progress of science and the useful arts by granting exclusive rights for the creation of writings and discoveries. And I just want to focus on that first part of the IP clause, to promote the progress of science and the useful arts. And so the ambition of the founders was to think through, how can we accelerate the diffusion of knowledge? How can we make sure that we see innovation happen here in the US like they were seeing occur in England and across Europe? That was their goal. Their ambition wasn't necessarily to make sure that folks who created things had a lot of money or received a huge profit, but really to focus on that education and that scientific discovery and the progress of society itself. So that's a very big, important charge. And that's where we eventually get the copyright acts that we've seen throughout history. So we've seen prior iterations of the Copyright Act. The most recent Copyright Act we saw was in 1976. And importantly, the 1976 Copyright Act is one of the most protective pieces of copyrighted works that we had seen up until that point. So just to put this in comparison, at the founding of the country, the first copyright protection was just 14 years with the possibility of being extended for another 14 years. Today, you get 70 years.
70?
70 years. Which is a tremendous extension of that copyright protection.
Absolutely. Yeah.
And it bears asking again, remember, the goal of the IP clause is the diffusion of knowledge. It's not to profit the individual creators necessarily. We want to incentivize them to create things, but the ultimate goal is furthering the distribution of knowledge. Who pushed for that 1976 Copyright Act? Disney.
Wow, really? That's
Why?
really funny because it's one of the things that we're going to talk about today. They're suing AI
Well, so
for use of copyrighted images.
Who do you think benefits most from the Copyright Act? Who's suing these major AI labs? It's not necessarily, in some cases, you see normal creators, quote unquote, normal creators, but The New York Times is suing OpenAI. Disney is
Absolutely.
very interested in this. We see big outlets like The Atlantic reaching licensing agreements. These
New
are
York
not
Times, yeah.
mom and pop creators, right? These are the big boys, for lack of a better phrase, of our media industry. So I just want to put all of this in a little bit of context of
Yeah.
who's really fighting for the protection of copyrighted works in the AI training debate. Now, you asked, Paula, what is fair use? So fair use is this doctrine where we'd otherwise say that the user of that copyrighted material was infringing on someone's copyrighted works. They were using it in a way that violates the protections afforded to the owner of that copyright. But fair use says, whoa, let's harken back to what is the original purpose of the IP clause, and let's make sure that we allow for some infringement, we'll grant an exception for some infringement of a copyright if it's used in societally beneficial ways. And there are 4 factors, but these aren't the only factors but that courts can consider. But they're the 4 factors that courts usually weigh. And those are whether and I'm just going to quote here, running through the list, the purpose and character of the use, the nature of the original work, the substantiality of what was copied, and any market harm from that use. So the first factor is that transformative factor that you raised at the intro, Paula.
Because that's what the companies, they're alleging.
That's what they're alleging. They're saying that we should be able to train on copyrighted data because the result is transformative. And it's transformative because we're either adding some new expression, or perhaps we're using that copyrighted work for an entirely different purpose, or we're otherwise transforming that original work. So that's what the labs are saying. They're saying that by virtue of using my articles, by virtue of using the New York Times articles, by virtue of using some photographer's photograph in the AI training process, the resulting AI model that comes about is transformative, and therefore it qualifies under the fair use exception.
Hello, it's just a quick reminder to let you know that you can also participate, be part of this podcast. So if you have a story to share or an insight about AI, please send me an email to paula@relatingtoai.com, and please do not forget to subscribe. Thank you. Oh, I understand that. But you mentioned that too. One of these 4, is it clauses? Do you call them clauses?
These are 4, we can say clauses, they're factors is how they're usually referred.
Okay. So one of these factors is considered when it comes to courts, is this fair use or not fair use, is whether or not it harms the market for the original. And when we go to these bots, and I believe I use bots a lot, and I've been now, because of the podcast and everything, I've been trying to create images and videos. I have to say there's a lot of hype, not that great. They're very good. I mean, the images are great, but are they really what you prompted? Not so much. But in any case, they're very, very good. They're convincing. And we're going to talk about some of these lawsuits later, but you can create, can you create this with the voice similar to Paul McCartney, for example? He's involved in a very, very interesting initiative that we're going to cover later on. And it does, and it's convincing. And how can they say this does not harm the market for the original? Can you talk about that a little bit?
So this is a highly fact-specific inquiry. When we're evaluating whether or not fair use should apply, we want to dive into the weeds of whether we are actually seeing, for example, an economic impact on Paul McCartney or J.K. Rowling, or you name the creator. And the argument from the AI labs is saying, look, it is very unlikely, for example, that someone is going to go to ChatGPT and say, I would like to see Tom Edstall's article from November 9th, 2024 in the New York Times. As it stands, for the average prompter, the person who just kind of lazily types into ChatGPT 5, show me this article, the odds of that article being perfectly regurgitated out is very, very low.
Mm-hmm.
Uh, if you dive into the weeds of this New York Times complaint, you will see that they engaged in a level of prompting of what we often refer to as prompt engineering that is atypical of someone who is not a computer scientist, for example. And they were only able to get regurgitated outputs, verbatim copies of New York Times articles by spending a lot of time pushing ChatGPT to say, give me it, give me it, give me it. I
Mm-hmm.
want to see that article. But Paula, you and I know that's not the way most people use ChatGPT. We don't
Mm-hmm.
spend hours and hours trying to get a substitute version of an article. In the same way, I think it's important to consider analogies to just how we interact from the day to day. So, Paula, you mentioned you may create some new song in the voice of Paul McCartney.
Mm-hmm.
Well, let's just consider you, Paula,
Mm-hmm.
just decide you want to become really, really good at singing like Paul McCartney. You train yourself for days after days. You spend every waking moment trying to become just like Paul McCartney.
Mm-hmm.
Now, Paula, I don't mean to offend the podcast host,
Believe me, I couldn't do that. My
but
singing
but
is horrible.
but let's say you do it. Are we
Yeah.
sure that people are going to come pay to hear from you or watch you sing Paul McCartney's music as opposed to just going and finding the original version of Paul McCartney? So these are the tough questions we have to
Yes.
evaluate of
Yeah.
looking at the fact specific inquiry. Are users really going to rely
Mm.
on some new version of Harry Potter, or are they just going to go to Harry Potter themselves? Because the difficulty is we all already have the power to create fan fiction, for example. I can go today and try to write Harry Potter book 13 where Hermione becomes the president, or you pick the fact pattern. But no one's going to want to buy that because it's not going to be very good. They want to read J.K. Rowling's version. And
Mm.
whether or not that's true, though, is what the courts get to decide. That's why fair use is highly specific. We can't
I
decide
see.
from the get go that this is going to necessarily impede that market for the original. We
Okay.
have to get into the nitty gritty details of
Of
the
the
economics.
specific detail of that lawsuit.
Exactly.
Okay, I hear it. Okay, but the other question that I have for you, though, it's very related to this, is what is copyrightable? And that's another controversy here today, and I want to hear you about this. So basically, the companies are saying this is fair use, it's transformative, and it doesn't harm the market, right? But at the same time, they're kind of protected when they say, what you create using us, we used all this creation here, we paid nothing for it, but what you create using us and what we provide you as a chatbot, for example, is not copyrightable. So you don't have the rights, we have it. So can you explain how that works? Because I know there is a new report by the Copyright Office here in the US, and it's a mess in itself. It's a very gray area. They already have 3 versions. One was July 24, the other one January of this year, and another one in May of this year. They're kind of writing as it goes. What is copyrightable today when it
Yeah. So
comes to
the
this report?
the US Copyright Office is in a bit of a strange state. So the short story, and folks can go to Politico if they want the long story or pick your news outlet.
Mm-hmm.
The US Copyright Office was assigned to analyze different copyright questions in these series of reports. So they've looked at, for example, the question you and I have been talking a lot about, Paula, which is the use of copyrighted information in the training process, does that qualify as fair use? So that's one question.
Uh-huh.
A separate question that you and that we're talking about now is whether the output from that AI model is protected under copyright.
Mm-hmm.
And just to go back to basics, because I'm a lawyer and we love to just read from the text, to be copyrightable, we have to see that a work satisfies 2 conditions. The first condition is that it is original.
Mm.
And this is the big qualification for this context. To be an original work, that means that it is independently created. And to be independently created, we mean independently created by a human. So we have seen cases, for example, where I believe it was an ape, in a zoo got their hands on a camera and managed to take a selfie, which is pretty fascinating.
Mm-hmm.
That was a work, though, according to the court litigating that case. That work was independently created, yes, but not by a human. All right. So
Oh.
we've seen a human requirement. So let's hang our hat on that
I
for a
see.
second. The second requirement is just that the work is fixed. So that means it has to be something that can be later perceived, communicated, or reproduced. And that's why copyright doesn't pertain to, for example, a live performance of some concert, for example.
Okay.
But it does pertain to a recording of that live performance. So going back to that first thing to emphasize on, which is originality. The concern of the courts and the concern of the US Copyright Office has been to argue that the output of a AI model is not independently created, that it is something that the machine is producing, not necessarily something that you independently have created. Now, Paula, you're going to love this.
I have 1,000 questions right now.
Yeah, you're going to love this case study. So there was a photographer, I believe in Colorado, or at least they won a Colorado photography contest. They won with an image in which they prompted that AI system about 900 times. I mean, something just extreme. So just imagine, I want an image of a meadow. In the lower right-hand corner, I want a fox. No, the fox has to look more red. No, the fox needs more fur. Imagine that for 900 prompts, or just hundreds of prompts. And the court maintained that that was not sufficient to grant copyright over that photograph. And so this becomes really, really tricky, because what we're seeing, Paula, is that you and I today could go generate 1,000 images. We could just go out and create so many new photos, so many different flags, you name it, we could go create it. Do we want to grant a copyright to every single creation?
Yeah.
Or how do we draw the line of, oh, well, if you enter 15 prompts, then that's enough? But they have to be detailed prompts. Well, how are we going to draw those lines? So these are some of the concerns around achieving the balance that copyright is intended to do, which is we want to make sure that we are incentivizing people to create things, but we also want to make sure that the creation, the knowledge, the facts, that can be disseminated across the country as quickly as possible. So the more copyright protection you afford, the less that information gets to spread to as many people as possible, as quickly as possible.
Yeah. Oh, this is so complicated. I mean, it's a huge gray area, because you're talking now, and I'm thinking, well, what the report says that if, and I'm going to read, because it's kind of clear, but it raises a lot of questions at the same time. What can be copyrighted? It says AI assisted works with human creativity. So the word creativity is key here, because it says works where a human contributor provides enough creative, expressive, or original, like you said, input through selection, arrangement, modification, can be protected. So I am thinking now, I'm a writer, I have 3 published books, and I'm thinking, okay, let's say I write a book, the main draft. I go to one of these bots and I say, can you help me edit? So it will help me with the edit, right? And I make some changes. But let's say I go to Midjourney, another bot, and I create images for my book. I didn't do a thing, because I can't draw. I'm not I can't do that. I'm a writer. So I use those images that came exclusively, even though I did the prompting, not 900 times, I'll do it maybe 10 times to kind of tailored to what I need, and I use those images. So I have images that were, let's say, 100% or maybe 90% created by AI, but I have the book that was 90% created by me, edited by AI. Is that copyrightable?
So, Paula, I'm going to give you my favorite answer, because it's everyone's least favorite answer from a lawyer, which is
Maybe.
It depends. It depends.
Yeah.
This is really why copyright law as it's emerging right now, which is case by case. So we have seen dozens, upwards of 36, and I'm sure that number has grown and it's growing over time. So many lawsuits with respect to copyright and AI. And the issue with that is, on the one hand, this is a great way to evolve what we refer to as the common law, right? It gives us a chance to slowly iterate on how do we draw these lines in a really murky environment. But if you're someone who is counting on AI for their livelihood, for example, or excuse me, a copyrighted work on their livelihood, and you're not sure whether or not you're going to get that copyright or not, well, that may, if you're unsure, that uncertainty may stop you from creating that work to begin with. And so that's the bad outcome we don't want to realize. But we also don't want to make it so easy to get a copyright that we see a lot of knowledge and a lot of innovation be granted some monopoly control by a single person for, like I said, a really, really, really long time. And so drawing that line is tough. And this is why some people are quite fine with the courts figuring this out. And that's going to take years, because we are just seeing the first wave. Those are in federal district court. Then they will go through the appellate circuit. And then most likely we'll have to wait for the Supreme Court to decide that issue.
Wow.
That typically takes at least a couple of years. Other people are saying, no, we need the legislature, we need Congress to act right now. And for example, to amend the Copyright Act of 1976 and just statutorily declare an exception, for instance, on training on copyrighted data, or to recognize a copyright for certain AI generated works. So it's a very fascinating time to be studying this issue.
Yes, Kevin, but it's been done. As you know, the European Union has done just that, and we will cover that. But I want to stay with this topic a little more, because we do have laws, and that's how the law is being changed over time in the U.S. It's usually through lawsuits, right? You change it by having companies or people sue other companies and stuff. So here we just had a few days ago, it was September the 5th, a landmark settlement. It's the first. We had Anthropic, which is owned by Amazon. They settled to pay $1.5 billion to authors. It was a class action. Many authors were part of it, and they agreed to pay $3,000 for each of an estimated 500,000 books that they used to train this large language model. So it's a huge settlement. It's a landmark. It's the first one. I have two questions for you. So first of all, it's not a law. So what impact does it have? Because it's a settlement before it became a law. How does that work in legal terms? What kind of impact can we see from a settlement like that?
By virtue of this being a settlement, this does not have any precedential effect. So typically when a lawsuit reaches final disposition, if you think about a court handing down an order, for example, that's when that decision may have some precedential value, which means other courts have to follow it. So every single court has to follow what the Supreme Court says is the law of the land. Every single court has to follow, and then if we work our ways down a little bit, we have myriad circuit courts, myriad appellate circuit courts, and every federal district court has to follow the precedent for their respective circuit. So the result of a settlement is we don't get any final order. So there's no law that now has to be followed by other courts. There's no explicit interpretation, for example, of the fair use exceptions in this case. And so the value or the legal impact here is not high, but the policy impact is huge, because now what this shows is that Anthropic was scared enough of the possibility that a judge was going to impose statutory damages for each and every copyrighted work that they trained on, that a lot of people regarded the sum total of those potential statutory damages as an existential threat to Anthropic. In other words, if the judge had declared that they infringed on the copyright of all of that class, Anthropic would have gone out of business having to pay those damages.
Yeah.
So they were scared enough that they said, okay, we don't want the court to force us to pay those statutory damages. So we're going to get ahead of the law. We're going to reach an agreement with that class and give them a little bit, not as much as we may have had to, but we're going to give them a little bit so that they're satisfied. So now, Paula, this sends a huge signal to the rest of the industry, which is, okay, if Anthropic is scared enough of the possibility of being forced to pay these damages, well, then maybe we should be scared too. And so we don't want to risk it. And so maybe we are going to similarly stop training on copyrighted data or to start reaching licensing agreements with some of these copyright owners.
Yeah. So it sounds like it was a legal strategy.
It's certainly a legal strategy where both sides are trying to estimate, okay, how likely is it that the judge is going to side in my favor? And that's the process of litigation, is you start to get exposed to, oh, okay, the judge, maybe the other party is making some really compelling arguments. Maybe they're not. Maybe I'm noticing the judge is tending to favor one way or the other. Maybe there's a recent court decision in a different district, which has persuasive value, not precedential value, but persuasive value. That's changing our calculation. So all of this math factors into, okay, should we settle or should we go forward with the litigation?
Yeah. And there are other authors that are independently pushing Congress here to act and to do something. I don't know if you saw David Baldacci. He was in the Senate Judiciary meeting in July. In July, and I'm going to read what he said, because he's saying, okay, yeah, I'll sue these companies, not a problem, but you guys here need to act and do something for the whole community. What he said was, what AI does is take what writers produce to teach software programs what they need to know. I have learned that these $trillion companies didn't even buy my books. They got them from a website that has pirated works. These companies have stolen our labor in order to make enormous profits, while we, the writers, the true source of all of this, have received nothing. So what is Congress doing, Kevin?
So I do just want to pause to kind of argue against David here for just 1 second, because his story of the labs stealing his books and not even having bought even one of them, I don't think David ever bought necessarily a copy of Agatha Christie's books. He probably went to the public library and got a version. I don't think David ever paid for a copy of or he wouldn't need to infringe a copyright holder for the creator of the Bible or for any historical novel or mystery novel that he's building on. We are the sum of reading information that's popularly available, of harnessing all of that and training our own minds on what to produce. And so here is where I push myself to the opposite side of the spectrum of a lot of people, which is to say, again, and this is why I teed it up at the start, what is the purpose of the IP clause? The purpose of the IP clause is to promote the progress of science and the useful arts. And AI tools, yes, they are training on copyrighted work. And it is clear that they are infringing the copyright of that work. There's no question about that. But what is the underlying purpose of the IP clause? It is to allow for the spread of knowledge across the whole of society. And AI, even though it's not great right now in a lot of contexts, but you can already go to places like the Alpha School here in Austin, where they're using AI, predictive AI, to allow students who learn differently, students who have different mental capabilities, students who learn in different languages, they can use these AI tutors to push their mental horizons, their educational horizons, to a level they otherwise never would have. You and I, Paula, we can go and we can use an AI tool to translate our works, our ideas into nearly every different language with a push of a button. we can see development of new AI assistants so that folks can go to the doctor and have medical reports broken down and explained in more accessible language. AI is the greatest engine of the diffusion of knowledge we've ever seen.
Hmm.
And so, and some folks may contest that, folks may say, no, AI sucks, to which I say, it's only going to get better. But it
Yeah.
will only get better if we have access to data. If you don't have good data, you won't get good AI. If you want data, if you want an AI tutor for your student because they learn differently, that data just doesn't appear out of nowhere. And so
Hmm.
we have to ask, who is this copyright protection actually benefiting? Is it just the David Balducci's? And it may be him who benefits, but what about the millions of other people who want to access AI and use it to expand their education and acquire new knowledge? So
Well,
that's the pushback.
I listened to the whole thing because this is an edit. What I read is just edited out of what he said, and I'm going to say what he said about that because it was questioned. He said, "Well, yes, I let's say Agatha Christie because he did mention many authors that he used and he loved, and he said I used them, the knowledge that I acquired for them to up my game." But here's the difference. When you go to AI and you say, here's the plot, you give one paragraph, I want a story about this, write as if you were David Baldacci. What happens? He said, you know why it reads like a David, but because it is David Baldacci. It's my books that it used. So what do you say to that?
Again, I say to that, let's just look at the fan fiction world, right?
Mm.
We see in the land of Harry Potter, there are tons of people who are writing other versions of Harry Potter. You can go online now and find so many different spin-offs. And yet J.K. Rowling's doing pretty dang well, right? I mean, there's a different set of folks who are trying their hardest to write like J.K. Rowling, but they're not winning in the marketplace. And
Mm.
so, are we seeing that big of an impact, even if people strive to emulate David? Then, if they write a better story, then
Mm-hmm.
sure, folks should be able to buy it. But my issue is we have to look at what people are actually doing in the marketplace and not just expecting that all of a sudden everyone's going to go on and read their own
Yeah.
version, their own
Yeah.
David. But in terms of what Congress is doing, Congress right now is not necessarily focused on the copyright issue. Congress tends to focus on whatever is politically salient at the time.
Mm-hmm.
So some of the most AI specific legislation we've seen, one bill is called the Take It Down Act, which refers to taking down content generated by AI that is intended to serve as a deep fake of
Mm.
a sort
I
of
see.
sexually explicit nature of an individual. That's the sort of content that has garnered a lot of headlines. We saw Taylor Swift, for example, was the subject of a lot of deep fakes, and that
Oh.
generated a lot of concern on the Hill and across the country. Congress responded. We've also seen that at the federal government level, President Trump, in remarks related to the AI action plan, has specified and outlined a number of policies for executive agencies. That AI action plan did not include copyright, but he
Oh.
did mention in remarks that he thought that copyright fair use protection should extend to training data. And at the state level, copyright is a federal piece of legislation. So there
Mm-hmm.
are some IP protections at the state level that they
Mm-hmm.
can tinker with, but really copyright is a federal matter.
Mm-hmm. Which is very different from what's being done out there, right? Because I think one of the worries, and we've heard this from the president of the United States, he alleges that, well, it's impossible for these companies to pay copyright to all this content. It would make it impossible for them to learn. And it should be used as I think he argues, common sense fair use. But EU, let's talk about Europe, right? 27 countries, part of the European Union, and they have what they already passed a law regarding copyright. It's called EU Artificial Intelligence Act. It's been enforced since August of 2024. And basically, the difference is in the EU, let's say me, I have my books. I can opt out of these systems. I can say, no, all my work cannot be used to train these language models. These chatbots cannot. You can opt out. So that's a law, very specific. So any of us, you as a researcher, know my articles will not be used. Why can't something like this be done here?
So something like that certainly could be done here. We could see Congress opt to amend the Copyright Act of 1976 to include some sort of opt-out provision. We could see, just by virtue of how the case law develops in the federal district courts and in the federal judiciary system, that perhaps we see that training on copyrighted work is not a fair use exception. And so that would effectively say, well, you can infringe, but you're just going to pay for each and every each and every infringement you incur. And so that's a sort of back way to a similar remedy. But again, I think that we're going to see a question start to emerge, which is, do you want to afford copyright protection to current creators, or do you want a more sophisticated AI system? And that's a trade-off, because we do know that the better data you have, the more quality and quantity of data you have, you get better AI. And so if we see training data start to disappear, then folks are going to see less reliable, less accurate, less useful AI tools.
Yeah. It's the risks too, right? It's really a gray area. And I just want to talk about two more things, and we'll wrap up the interview. One of them is we already have, and I think what makes it even more complicated in the US is that everything is state bound. It's not, you rarely see like a national law. In Brazil, any law, and by the way, they just approved in the Senate in Brazil a new law regarding AI and the opt out and compensation, and it goes through all of that. But here, you have every state will have their own laws. So we have in Tennessee from March last year, they have one specific, it's called the Elvis. I'm a big fan, so I like the name. Elvis Act. It's insurance the voice. It's actually based specifically for musicians, for the music industry. The voice cannot, they protect their voice against misuse of these chat bots. So from this AI generated synthetic media. So you can't use their voice. If they find that the voice was used for that, that's protective. So, but that's in Tennessee. It's one state, one specific law. Again, can this be replicated? Can other states? Because now it's a law, it's not a settlement.
On the Elvis Act, this is something that other states could certainly replicate if they wanted to. It's also something that Congress could choose to replicate. And if Congress does replicate that, then as you noted, Paula, that would become the law of the land for the entirety of the country. The question right now is, do we have concerns about 50 different states passing 50 different versions of the Elvis Act? Because even though we may think that OpenAI, for example, can comply with 50 different versions of the Elvis Act, they can have the policy people studying these issues, the lawyers to study these issues. We have to ask about who are the startups, the true startups, not the Sam Altman startups who have, $1 trillion valuations soon or eventually. What about the small startups that don't have a public policy team and don't have tons of lawyers to try to navigate that patchwork? So these are the really tough questions we're grappling with. Unfortunately, I don't have all the answers, and it's a bit of a wait and see moment. So it's going to be really fun to see how things evolve.
Yeah, so one last question, because this is a segment that every episode, it's more personal. It's a segment called One Last Question. So my question to you is, you are a teacher. You are not just a lawyer. You're a teacher, so you influence a lot, hundreds of students every year at the University of Texas. What do you think your responsibility is when it comes to copyright and what you teach, these messages that you pass on to your students?
I think the most important value I can teach is thinking about the underlying purpose of innovation in society. So we know that spurring creativity, spurring the diffusion of knowledge is one of the most important things any society can do. If you don't have the spread of knowledge, if you don't have the spread of ideas, you stagnate and you see people fall behind economically, socially, culturally. And so, how do we think creatively about the best ways to harness existing technologies as well as prior technologies
Mhm.
to unleash that innovation? And if I can inspire my students to think creatively about that question, then I've done my job. Regardless of their conclusion, if it furthers innovation, I'm a happy camper.
Thank you so much, Kevin. You have a great day and go teach your students.
Thank you, Paula. I appreciate it. You too.